Hello, so good evening. So I am about to discuss Indian polity. So UPSC previous year questions, UPSC previous year questions on Indian polity. So two or three sample questions. So here is the first question. So the question says that which one of the following categories of fundamental rights incorporates protection against untouchability? So as a form of discrimination, right? So as a form of discrimination. So the Indian polity, so basically is listed in, fundamental rights are listed in part 3 of the Indian constitution, right? And in fundamental rights we have different types of fundamental rights. So the options are given here. So the first option says that right against exploitation, right? So the right to freedom, right to constitutional remedies, and right to equality. The question says that the protection against untouchability so has been listed in which type of fundamental right. So if we talk about right to equality, right, so right to equality, so which is listed in article 14 to 18, right? So from article 14 to 18. So in fundamental rights, the other rights are right to freedom, right? So right to freedom, so basically 19 to 22, and right to or right against exploitation. So right against exploitation is listed under 23 and 24. So then we have religious rights, right? So religious rights and minority rights basically. So religious rights are from 25 to 28, and rights of minorities to establish institution, right, and to protect their language, culture and all is listed in 29 to 30, right? So then we have the right to constitutional remedies. So this question so basically is talking about untouchability. So untouchability is nothing but discrimination against few people, so based on their religion, caste or race, so which is in practice even today in some part of India, especially in rural areas, right? And this practice is there in India since ancient times. So basically based on the Varna system, many castes were divided from the religion, right? And some people, so basically we talk the Varna, the Shudra, so there was a discrimination in the forms, right? So if we talk in practice, like there was no entry for those people in temple, or there was a no entry for few people in public places, so let us say hotels and restaurants, etc. So this untouchability has been listed in this right to equality. So basically article 17. So article 17 talks about the protection against untouchability. So my answer is right to equality, right to equality. So next, if we talk about next question, so this question says that with reference to provision contained in part 4 of the Constitution of India, so which of the following statements is or are correct, right? So part 4, nothing but the DPSP or Directive Principles of State Policy. So DPSP or Directive Principles of State Policy, so that is part 4, right? The statement says that they shall be enforceable by courts, right? And statement 2 says that they shall not be enforceable by any court, right? So if we look at the statements, statement 1 and 2 are conflicts, so they are in conflict, right? So basically opposite to each other, and the principle laid down in this part are to influence making of laws by the state, right? So yeah, so from 36 to 51 basically in part 4 of the Indian Constitution, So article 36 to 51. So DPSPs are listed, directive principles of state policy, so which are nothing but the instrument of instructions, right? The instructions the government or the lawmakers needs to be followed while framing laws or policies, right? So the article 36 here explains about state. So basically what is state and what should be considered as state. And article 37, right, article 37 quotes that the lawmakers or the state needs to follow this principle while framing the laws, right, which means these three is correct, right? So 3 is correct. The principle laid down in this part are to influence making of law by the state, which means so C and D, right? So there is, the answer is between C and D. So then we will look at the statement 1 and 2. So they shall be enforceable by courts and they shall not be enforceable by any court, right? So few part of the constitution, right, which are not enforceable by court, or basically they are not justiciable in nature, right? So justiciable in nature. Justiciable in nature means we cannot go to court to enforce these principles. So especially some of them are the preamble. So preamble is also not enforceable by court, right? And especially the DPSPs are also not enforceable by the court, right? So statement 1 is correct. Statement 1 is wrong. So we can eliminate this one. So answer is 2 and 3. They shall not be enforceable by any court, which means we cannot go to court if the DPSPs are not implemented or enacted. But however, the article 37 itself says that the state or the government or the lawmakers has to take into consideration the DPSPs listed in part 4 of the constitution while framing the law, right? Option is D. So 2 and 3. So last question. The constitution, consider the following statement. The Constitution of India defines its basic structure, right? So we can read this statement carefully. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights and democracy. Okay. The Constitution of India provides for judicial review to safeguard citizens' liberties and to preserve the ideals on which Constitution is based. Right. So which of the following statements given above is or are correct? So option A says that 1 only, option B 2 only, and option C both 1 and 2, and option D neither 1 nor 2. So look at this statement 1, right? It is talking about the basic structure, right? So nowhere the basic structure is mentioned in the constitution. So basically it is by the act of judiciary, right? So it is by the act of judiciary, or we can say the Supreme Court in its rulings. So basically in Keshavananda Bharati case, right? So Keshavananda Bharati case. So Keshavananda Bharati case in 1973, the Supreme Court, right, so talks about the basic structure. So basically the question was about amendability of the Indian Constitution. So amendability of the Indian Constitution under Article 368. So in the previous cases or previous judgments, right? So in basically the Shankari Prasad case, right? Yeah. So so amendment was not available for the fundamental rights. So again the Golaknath case and Keshavananda Bharati case, right? So finally in Keshavananda Bharati case, the Supreme Court declared that yes, the Constitution can be amended under Article 368, and even the so basically the Parliament has got the power to amend the Constitution under Article 368, but without destructing the basic structure of the Constitution, right? Which means, so there is no word like basic structure in the constitution itself, but it has been introduced by the Supreme Court, right? So through the act of judiciary. So hence the statement 1 is wrong. Statement 1 is wrong. And if we look at the statement 2, the Constitution of India provides for judicial review to safeguard the citizens' liberties and to preserve the ideals on which the Constitution is based. So yeah, so basically Article 13, right? Article 13. So there is a concept of judicial review, right? So there is a concept of judicial review, but the judicial review itself has not been declared, right? But the process, so basically any act, right, or the law of the state, if it violates the principles of the Indian Constitution, right, it can be called in the court of the land, right, or basically the Supreme Court. So statement 2 is correct. So my answer is 2 only. So I hope you got your answer or the questions were clarified, right? So thank you.